Ronak, is the video better?
Yes, sir.
Okay. So when I became a lawyer in like 17, 18, I started working with an advocate on record. And most of the time it would become my duty eventually to go to the registry and clear the files who have been held in defects. So what would be the defects which registry will ask me to cure? They will tell me that your documents are not proper, they are not legible, they are not visible properly, or most of the times they are in regional languages. You go ahead and translate them. So then I will note down all the defects and problems raised by them and sort them out one by one. It might take even 1 or 2 weeks to clear those defects. It becomes really difficult to explain a client why your case is not getting listed. But believe me, this annexer portion is very difficult. So you need to be very diligent with your documents. Please sort out your documents before filing a case properly. Get real copies, get entire copies. If they are not legible, get them type yourself or get them translated. English is the language which is recognized across the country, across the forums. So this is the way to go forward. If there is some defect in the documents, cure them before the litigation starts. Because it might happen that litigation has started, it has gone for 30 years, and someone will say, okay, this document is incomplete. And the judgment was given without seeing the complete document. And so another thing will start. So please don't do that. Be diligent with the documents. I have taken 5 minutes about documents. People would say, okay, why did you take 5 minutes? But if we are discussing rates, if we are discussing filing cases on original side, I think we need to discuss these documents, because if we don't discuss these documents, we are missing out on something important. Documents are very important. You need to keep them diligently and present them very nicely. Otherwise, defects would come, and it may happen that registry will pass it, and years later, someone says that, okay, these documents are not sufficient or relevant or incomplete. So you can't afford that. Then at page 7, paginated page 7 is optional section. Why we call it optional? Because we move multiple applications there. For example, exemption application. We are in digital age, yes. So you go to High Court, you argue a matter, and and your case gets dismissed. Your writ gets dismissed, and your order get uploaded in the evening only. So by evening, you have a PDF document, PDF order. If you apply for the certified, it might take 2 weeks. Why do you need 2 weeks? So if your writ petition gets dismissed by a single judge, you go in a writ appeal in the same High Court. You don't go to Supreme Court directly. When your writ petition gets dismissed by the single judge, you go and writ appeal in the same High Court, and it goes before a division bench. So when you are going before the division bench, you don't need to wait for this. Yes, I will identify statutory authority and department. So when you are going to the appeal, writ appeal, you don't need to wait for certified copy. You can annex this digital PDF as the impugned order, the order which you are challenging, and you can move an exemption application of one page saying that please grant me exemption. I can't produce certified because it will take time, and exempt me. So this annexer, this miscellaneous application will go with the petition. And another application is very important, and that application is called interim relief application. Believe me, a lot of senior lawyers say it. I am saying it to you. Like 3 years back, when like I was preparing for AOR exam 2 years back, I went to listen to the lecture of respected Attorney General of India, Venkat Ramani Sahab. So Venkat Ramani Sahab said this thing, and now I have come to realize that he was right in saying so. That if you don't get interim reliefs, no client is going to come back to you. So interim reliefs are very important. If relief is the important, so is the application. You need to be very diligent with this application. How do you get a stay? Order 39, Rule 1-2 of CPC defines how do you get the stay. So for getting a stay, you need to show 2-3 things: that you have a prima facie case, that it's a likelihood that you will succeed in this case. You need to show the irreparable harm, that if there is a demolition order against my house and the order says that on 24th July at 10 a.m. it has to be demolished. And if the stay is not granted today and the date is given for 5th August, then what will happen to my writ? The house is already demolished. You need to show the irreparable harm which can't be undone, and the balance of convenience. Reconstructing house is tougher than not demolishing it. So the stay application needs to be very meticulously drafted and needs to lay out all these grounds which become necessary to grant a relief in your favor. And the last one is your authorization. That's called wakalatnama. Wakalatnama is nothing. It's just an agreement between a client and the lawyer saying that the client will say in that it's a very fixed format. Every high court has its own format. It simply says that I authorize the lawyer to file this case. I authorize the lawyer to appear on my behalf. I authorize the lawyer to take the decisions on my behalf. So basically, it's an agreement between lawyer and the client, wherein the client gives all the authority over this case to his lawyer. So this is wakalatnama portion. And in the page 8, we have this drafting prayers and reliefs effectively. How do we become effective in drafting prayers? Be specific. Don't use vague terms that grant me justice, grant me fairness. You tell me how do you grant me justice. Like if someone's house is getting demolished, justice would be to stay that demolition for the time being and listen the party, what he has to say, what documents he has to say. So rather than being vague, rather than using rosy language, you can use simple words, simple sentences, and be specific. That's the one. Second thing is be a little terminology specific. Use words like issue, direct, quest, declare. It makes it more formal. You don't need to become very pedantic in your approach, but you can be a bit formal. And again, your prayers need to be aligned with the grounds. It can't be a case that you make out a case for demolition of the house and then you go and pray for permanent appointment. It can't be like that. It has to grow in a very scientific manner, that one by one you lay down the fact, you lay down the ground, and there are prayers. And these prayers have to be specific, separately numbered, and residuary prayers need to be there. By putting residuary prayer, you give ample opportunity to the court to do something for yourself. I will demonstrate it by way of the judgment in the later part. And obviously, you can't be too greedy. If you start claiming everything, then the bench might not be very happy with you. And this is all about the prayers. And in the next page is, I think, the very important part, drafting interim reliefs, page 9, and the stay applications. As I have said, it's very important. You need to get the stay. As a client, you deserve a stay. Otherwise, someone will come take down your house. If you are saying that authorities need to make you permanent employee, and during the pendency, the authority becomes so angry with you that they throw you away and dismiss you, so that you need to make an application saying that during the pendency of the petition, no coercive action has to be taken against the employee. So these applications have to be there. Employees need them for litigants need them for the protection, and the lawyers need them so that they can show that they have done something for them on the day one, so that the trust remains. The final disposal of the writ might take years, but on the day one of the writ, if you get interim reliefs, then your client is protected from the day one, and you have achieved something at the inception, and that counts, and that adds in your credibility. You become a credible lawyer. So a credible lawyer is someone who gets interim reliefs on the day one. And how do you get the relief? By drafting good petitions and presenting the case with patience and nicely. You indulge everyone. See, in chat box, whatever queries are falling, I try to address them. That is indulging you. So when you go in court and present your case, you need to indulge everyone. If you are making a very nice argument and court throws a query at you, rather than completing your argument, you need to stop and address the query. By doing so, you show that rather than my words, your concerns count a lot. And this is how it should be. So in this part, prima facie case, stay application, irreparable injury, balance of convenience. So this thing is there. And there is a case which we have given in the compilation. In bookmark section, you can go to Ogla Tallis. In that case, the interim was granted because that case related to slum dwellers, people who live on the slum, who live on the pavements, who live on the street, and they were being evicted in Bombay. So those poor people, needy people, went to High Court, and eventually the matter reached the Supreme Court. So the first thing which happened was the stay. The court said, okay, before we decided, do nothing. And this is how the things move. So the lawyers were smart. They drafted this stay application. They showed the court that if you don't stay the authorities, harm will happen. And the lawyers were able to show the court, and they got the stay orders in their favor. The next at page 10 paginated is common drafting mistakes and how to avoid them. Vague prayers, don't make vague prayers. The prayers, the requests need to be specific. Otherwise, they won't know what is to be done. If you see the cause list, by cause list, I mean the list of cases before a court on a given day. The list is never small. Today, I was in High Court, court number 6, Delhi High Court. And in my court, there were 72 matters. And believe me, when our division bench, honorable 2 judges listen you for like 72 matters, they want someone saying specific things. So don't be vague. Don't say grant me justice. Tell them what you want. Tell them you want permanent appointment. Tell them you want your house to be safe. You tell them you want a friend of yours who has been detained illegally to be released. Be specific. Don't be unstructured and like grammatical mistakes, spelling mistakes. Those things should not be there. And believe me, in this age of technology, it has become really easy to avoid all this. You type on Word, and Word tells you that there is a spelling mistake and you correct it. So even in this age, there are spelling mistakes in the petition. It looks really bad. It shows that you are not even looking at the machine. Laptop is a machine. You are not even listening to the machine. So you have not been diligent in doing the work. So please avoid spelling mistakes, grammatical errors. Please avoid them. There is no need to use very rosy language, big words, big sentences. Use small sentences, small words, but be specific with them. Make out something. That's important. Don't write irrelevant things. So if a house is being demolished, it doesn't mean whether the owner is a PhD or a farmer. These things are not relevant. What is relevant that a family lives there? What is relevant that sick people live there? What is relevant that if you don't stop the demolition of the house, those people will come on the street and some infants might even die in the chilling winter. Those are the relevant facts. You need to state them. If you rather go ahead and say, that's it, gentleman went to Cambridge, did a PhD, it's not relevant. You only write relevant things. And you support your government with the documents. If you don't have the document, don't make a serious submission. If you are saying that particular authority has been corrupt, now this happens a lot. Corruption allegation. Everyone faces it every day, day in, day out. So if you are saying that the demolition order has been passed by MCD because those people came, asked some money, and you denied it. If you are making such an allegation, you need to have the documentary proof. If you don't have any proof, I think it's better not to make such submission because it makes the entire case frivolous. You need to show that something wrong has happened. You need to show that those people come to your place. You have some CCTV footage. You have some call records. You need to produce all of them. If you don't have all that documentary backing, then please don't make such submissions because they will never stand in the court. Because there is always an opposite party that a party will come and ask for the documents. They will say that you are lying on oath. You say one thing, they will say another. And where does it go? It goes nowhere. And that doesn't serve your purpose. So when you are making a submission, it's necessary you support them with some documents. If you don't have the documents, there are better ways to do it. And that's called legal advice. Take better legal advice. But if you are making some submission which is serious in nature, which is saying that someone was supposed to do something, he did not do that thing, and he wanted something which he was not supposed to want. In those situations, you need documentary proof. And then citing law is good. Citing case laws is good. But citing wrong case laws is bad. Like it happens with a lot of law students that they invent case laws while writing their exams. And sometimes it flies, sometimes it fails. Most of the time it fails. Don't do it before the court. You can be held in contempt. Even the lawyer can be pulled up. You can't be writing anything bad. You can't be writing anything which is incorrect. You can't be making up law. You can't make up the law. If you are so serious to make up the law, become a parliamentarian, become a judge, then your judgments will become the law. Your law made by you will become the law. But you can't make up the law yourself. If you are wrong on that part, then the petition is gone, the case is gone. Court rules have to be complied with. Those court rules are there. High Court has its own rules. Supreme Court rules 2013 are there. Those rules are comprehensive. That's why there is a term called local lawyer. So recently I went to Pune for a POXO case. There was a child who had gone to jail. We pursued that case and eventually we got bail within 20 days. And as per the local lawyers of Pune, it's an achievement because in such cases you don't get bail those easily. But our case was strong. We pursued it very diligently. That's why we got some favorable outcome. But in that case, the most favorable thing was a very diligent local counsel. Local counsel is very important. Why you always have a local counsel? You can practice all India basis, but you need to have a good local counsel, a gentleman who knows the code, the gentleman who knows the local rules, the gentleman who knows the local customs. That when you file a bail, it will be put up at 2 p.m. or 3 p.m. With the bail, this document will go, this document will not go. Not only high courts and Supreme Court, even the district court has its own rules, regulations, and customs. You need to follow them if you want relief. You can learn by trying, but if someone is in jail and if you are trying to learn by trying trial error method, then you are learning at someone's expense. Never do that. If you are going for an outside matter, I am Delhi based. If I'm going to do a matter in Karnataka, it's better to engage a Karnataka lawyer also. I can go there, I can draft it, I can argue it, but he needs to be in the team. He needs to tell me when the matter will be listed. He needs to tell me what are the rules, what are the regulations, so that I don't learn at the expense of my client. And that's very unfair. Learning is good, but at the expense of a man who came to you to seek your protection is the most unfair thing. And I think it's a professional misconduct. So this local rules is very important, their compliances. And it's always good to have someone in your team who knows them, is well versed them, and has been doing same on regular basis. If you want something on urgent basis, always put this urgent application, hearing application. Then we come to page 12, page 12. It's about procedural rules. Every high court has its procedural rules. And again, things get divided on the civil side and criminal side. So if our writ is of criminal nature, right, a writ of habeas corpus, there would be a lot of procedural things. Those procedural things in routine would be covered by CRPC, now BNSS, Criminal Procedure Code 1973, now Bharatiya Nagrik Suraksha Sanhita 2023. So all procedural things would be supported by BNSS on the writ which is lying on the criminal side, like habeas corpus. Same time, vice versa, a writ which is on the civil side, like a writ of mandamus against dam city, demolition orders, then that writ would be on the civil side, and all the procedural things would be done by CPC provisions. But again, writ proceedings are summary proceedings. They are not bound by those procedural aspects and technicalities. In general, for ease, those things are used. Even High Court's rules, Supreme Court rules are used. But at the end of the day, all those rules are procedural in nature. They are there to help the justice. If those rules are becoming a hindrance to the justice, then in opportunities, in situations, court bend those rules so that fairness can prevail.